I think it's the afternoon, or it's around the afternoon. Anyways, good afternoon or good morning, whatever it is. I'm really sorry for the delay. I had to arrive yesterday, but my flight got cancelled and there was no other flight, so I took it today. I just arrived. Thanks to the organizers, to Nitin and especially to Arun, who have been coordinating with me and who have invited me on this colloquia. And then to my Professor Srinivas, he has taught me, so I don't know how much I would be able to contribute from this side in his presence, but anyways, I'll try to. I have some ideas. In fact, I have been working since the time I got the topic on this, very confused what all to include, because when you're talking about teaching of international law, first I was confused whether I should discuss the method of teaching, whether I should discuss the manner in which students are to be engaged in the classroom, or students are to be engaged in research, whether it means that, or whether it means a general study, a general learning of international law, wherein you organize, for example, a colloquia like this, disseminating information, disseminating knowledge and other things. So I'll share some of the points that I have in mind, which I think are very, very relevant, at least what I think. Now the first question that comes to my mind when I see the topic, I'm not going into the formal structure that I prepared for the lecture, because that would be very boring, since we have a discussion session as well. Now the first question that comes to my mind when I look at the topic is, why? Why do you want to teach international law in the South? This is the first question that comes to my mind. The second question that comes to my mind is, what is this South? Is this, and I remember I discussed with Arun, in fact I discussed with Professor Srinivas as well, we are having a program not only in the south of the world but also in the south of the India. Okay, so what do you mean by South? Number two. Number three, the question that comes to my mind is, why it is relevant to study or teach or learn international law in the South. I want you people to understand one thing, and that is, international law as perceived by Asian scholars has been different from international law as it was perceived by the European scholars. And there has been one reason, one very big reason. Because European nations had a different history. They had a different inclination. They had a different experience. Now, when you look at the sources of international law, if you have looked at the most identifiable source of international law is said to be Article 38 of the ICJ Statute. Now, if you look at the ICJ Statute, Article 1 is the treaty, 1A is the treaty, 1B is the custom, 1C is general principles. Now, when you look at the treaty, the custom, this treaty custom narrative tends to be localized in the European context. I want you to appreciate this. Professor James Crawford, he wrote an article defending that Australia has a good amount of literature, a very rich literature on customary law. He had to write on this because Australia was not seen to be a developed nation. And since it was not a developed nation, it did not have a say in the treaty, in the custom narrative. It did not have a space for that. So the international law that we learn even now is very, very dominated by the literature from the Europe, number one. And that is one of the reasons when we study international law, we have to take a very special approach of studying international law in the South, because South is different from the North. Now I'll give you one example. Why study of international law becomes problematic when you study it in the same manner in the South. Now look at the problems that, for example, South Asia has. South Asia has the biggest population in the world. South Asia is most prone to natural disasters. South Asia is most prone to refugee problem. South Asia is most prone to environmental problem. South Asia is most prone to economic inequalities. And the instrument that you're talking about, that is international law, has nothing to say on this. International law is very silent on this. It is not inherently, it does not talk about the issues of justice. It never talks about the issues of justice. Look at the, and I remember, I was, listening to a lecture, in fact an interview. There is a famous third world scholar, Anthony Yankee. Now what he said was very interesting. He said, international law, even if you look at the UN Charter, it talks about justice. It says justice is our objective, to reduce human suffering, to reduce, to negate war. This is our objective. But once you look at the manner in which international law is applied, it does not look at justice. That is a very, very big problem. Now, I'll give you an example. Look at WTO. World Trade Organization settling dispute. I asked some of my students whether judicial process is a justice dispensation process. And they said yes. But the answer is no, not always. Judicial process has two phases. The first is the settlement of dispute, and the second is the delivery of justice. Now if you look at the international tribunals, they do the first, they do not do the second. They do not do justice. They do not tend to do justice. Now look at the decision of ICJ in the legality of the use of threat of use of nuclear weapons case. ICJ had a chance to say that nuclear weapons cannot be used. But what ICJ did? It said, well, there is no principle in international law. Okay, so ICJ could have done that. So when you look at international law functioning, it is not discussing too much about justice. This is the first point. Second point is, now while I am saying this, that it is not inherently talking about justice, I am not saying that it does not talk about. It has started to talk about justice slowly and slowly. Okay? What I think to my mind is the first example. Prohibition of war, prohibition of force, use of force is what? It's a concept of peace. Then comes human rights. Then comes protection of human rights. Then comes criminalizing the act of gross violation of human rights. So slowly and slowly the element of justice is coming in. But even now, even if you look at the working of International Criminal Court, which is talking about criminalizing the gross violation of human rights, well, South Asia or the Asian nations do not suffer from this problem. They suffer from the problems of, as I said, economic inequalities. They suffer from the problems of natural disasters. They suffer from the problems of refugees. They suffer from the problems of, health. Even Africa. So when you look at international law, and when you say international law is a very useful tool, international law is very, it's very empowering, we should study it, it becomes irrelevant from a third world person's perspective. So what has to be done? A third world person has to reinvent the study of international law, because there is no use in challenging it. There is no use in challenging the already existing. One interesting example would be that there was a letter written by a number of scholars. Matthew Craven, even James Crawford was also there. In 2004, I think they wrote a letter to the Guardian newspaper when US and UK, they were about to attack Iraq. So they wrote a letter to the Guardian, and then they said, well, whatever you are doing is wrong. Whatever these countries are doing is wrong. This is violation of international law. Okay. And then no one listened to them, and the war happened. Okay, they attacked Iraq. And then a second letter was written by another set of scholars as a rejoinder to the letter that these people wrote. And they said, whatever you are saying is true. Even if we accept it, it is true. But you need to understand one thing, and that is international law can have many different interpretations. So do not say that your interpretation is the only interpretation. Okay? Now what happens after that? After that, these set of people who wrote the first letter, they write an article in a journal. I don't remember the name of journal. They write an article in the journal, and then they accept that, for example, we say America and UK, they invade Iraq. It is a violation of international law. They have violated international law. So what? So they accepted the fact that when we say this, inherently we are also challenging international law, because we are making it at the end of the day irrelevant. Because people are saying, well, there was international law, it's violated. Then what? Is there a solution in international law? No, there is no solution in international law. Okay? So what I am hinting at is, you should not have the tendency to challenge the already existing sets of principles. Because if you challenge, you do not have a solution. Okay? You do not, so if you say this is clear-cut violation of international law principle, the other person will say, well, it is violated, then what? This means that the international law that you have been talking about does not have the power to deal with these kind of situations. It is irrelevant. Okay? Same is the case here. If you say international law is not looking at the interests of third world nations, and hence we should change international law, once you have said this, you will make international law as a tool irrelevant, and you won't have anything else in its place. So the best way is to try to reform and bring in your own ideas into it. This is what the third world scholars have been doing through the third world approach that they have developed. They are not challenging international law. They are bringing in new ideas to reform it. Okay? And that is how you will make it relevant for the people of third world. So that was the first, that was one of the questions that came to my mind. Then one very important question that comes to me is international law as a subject, as an area, as a tool so much important that we are putting so much of our stake onto it? Is it capable of dealing with such big problems? That is the second question. Why do we say the problems of, for example, the problems in Syria, international law has to resolve it. The problems in Yemen, international law has to resolve it. The problem of climate change, international law has to resolve it. The problem of genocide, international law has to resolve it. Why not politics? Politics can also resolve it. Now, what I'm emphasizing is, I'm saying, I'm trying to convey the message that international law is like a pen. It's a tool. You use international law as a tool. Okay? So, if you look at international law as a pen, as a tool, don't you think you are putting too many promises on international law? That it will be able to do this as well, this as well, this as you have this pen, you want to draw with this pen also, you want to write with this, you want to, draw a sketch and everything. Don't you think you are putting too much of, promise on international law? And I remember I had a discussion with Arun few months back. We were discussing about global justice, some of the ideas, and the answer to the question that I have posed is, you do not have any other choice. Tell me any other alternative tool that you have to deal with these problems. You do not have. If United Nations is incapable of doing something, do you have an alternative to United Nations? You do not have. Because it is almost universal in membership. Do you have any other body which is almost universal in membership? Look at the ICC, International Criminal Court. African nations are trying to move away from the International Criminal Court. Do you have a body like this? You do not have. So what is the solution? The solution is to discuss it within the paradigm of already existing international law. You cannot just negate the tool, you cannot just negate the international law study saying that it has no relevance with my aspirations, my problems of the South. Hence, it is not important for me to study it. You do not have any other tool, you do not have any other solution in fact. These are such big problems. Okay? So, I think we need to emphasize on this aspect also when we are studying international law, that it is actually very, very important. Not only because we should study it, but because we must study it, there is no other alternative. Okay. Then one again very important question again I think is, when we say teaching international law in the South, whom are we going to teach international law? That is a very important question. Are we going to teach international law to the students? Now, whatever literature I have read, American Society of International Law, even the International Law Association, they all say that students are not interested in studying international law because it is not giving them job. So we have to make it more job oriented, practice oriented, and we have to make it more interesting. That is one of the reasons why Hague Academy, involves itself in so many activities, so to disseminate the information, so that people get involved into it. So are the students our only target audience, or should we engage other audience as well in international law? For example, look at the problem in Syria. Look at the media, what media is giving you. Look at it. The entire narrative of media is a political narrative. Okay? Russia and Iran, Saudi Arab and US, it's entirely political narrative. Okay. Now the same set of incidents can also be interpreted from international law narrative. We have international law narrative of this, You cannot use force, you cannot interfere, you cannot do this. You cannot enter into gross violations of human rights, you cannot violate Geneva Conventions, you cannot violate humanitarian law. You have international law narrative also. But that international law narrative is not coming in the media. Okay? So the picture that is portrayed is this set of incidents can only be interpreted in this manner. This is the only way in which it can be dealt, and this is the only manner in which it can be resolved. So it's not only the students, it's also the media that becomes a target audience. Okay? Because you have to also, I hope I'm making sense. I did not ask in the beginning. I hope I'm making sense. Okay. Now, so that is again a target audience for you. Because everything, I know there is a political narrative, but political narrative is not the only narrative. You have an alternative narrative also for that. And then, interestingly, in one of the articles, it was said you have to take international law to the masses as well, to the people. Why? Because people also have opinions on the invasion of Iraq, on the invasion in Afghanistan, or on Twin Tower attack. Okay? Or probably they are not, many people do not know this, the climate change and other things, but yes, people who read newspapers, they have, a take on all of these issues. But the problem is, all this understanding is purely political. There is no law in it. So whenever, and this is my personal experience, whenever I teach my students, the biggest hurdle for me is to tell them that you can dabble with law and politics in your entire life, but you should first understand that this is law and this is politics. And that is the biggest problem. Whenever I interact with anyone, he says, what do you do? I say, I teach. What subject do you teach? International law. What is international law? Yeah? This is doing that, America is doing that, UK is doing that, Russia is doing that, Saudi Arabia is doing that. There is no international law. It's all politics. What do you say? What do you teach actually? You teach nothing. Okay. So international law narrative also has to be given on a, it has to be disseminated to common masses as well, even though that's a very far-fetched dream, very far-fetched idea. I'm not running, how much time do you have? 5 minutes. I have 5 minutes, okay. Now, one again interesting thing is the methodology, the pedagogy that I was trying to discuss here. But then I was told it should not be very boring for the people, so I said, okay, I'll not use those things. How should we study international law? And I take ideas from Ilayaraja sir, what he said. We need to, and in fact, this was also observed, not only observed, it was resolved in one of the sessions of International Law Association. International Law Association as a group that deals with teaching of international law. So it comes up with its reports. So it was also resolved in that, the meeting of International Law Association that we should have a minimum repository of resources for people who wish to study international law. Because when you deal with teaching of international law, study of international law, learning of international law, it should not stop at we discussing things and going away. Okay? So they resolved that we should create a minimum repository of resources, and this was not felt by only them, even American society has this. American society has a basic electronic resource guide on different aspects of international law. Okay. So I think this center, the Alumni Association of The Hague, you people can take a step forward at least in this, even if a small step in this direction, to at least start compiling the materials, the basic materials that can be used by anyone easily, whomsoever wishes to study. I'll end with this. Thanks very much. Thank you.